Okay, we got it. All right, well, since everyone's assembled, the time is 1 p.m. or thereabouts. We'll get started. I call to order the September 18, 2024 meeting of the Legislative Committee of the Contractors State License Board. I am Joël Barton, Legislative Committee Chair. Please note that only board members who are members of the Legislative Committee may participate in the committee meeting. Other board members who are in attendance may observe but cannot ask questions or participate in the discussion. The purpose of today's meeting is to provide a public forum to discuss if there are ways to provide additional consumer protection for residential construction in the Contractor State License law. Because the teleconference committee meeting is remote, committee members cannot make recommendations or motions. However, committee members can gather information, receive comments, and legislative suggestions. Committee members will be using cameras during this meeting. The law requires committee members participating in this meeting to have their cameras on. Please have your camera on for the duration of the meeting. When you would like to comment during the meeting, please select the raise your hand icon in the WebEx application. Our moderator will call on committee members to speak. When called upon, please unmute yourself, and when finished, return to mute. Robin, please call roll and confirm we have a quorum.
Joël Barton.
Here.
Rodney Cobos.
Here.
Miguel Galarza.
Here.
Amanda Gallo.
Here.
Diana Love.
Here.
Thomas Ruiz.
Here.
We have a quorum.
Thank you, Robin. At this time, I'd like to ask everyone to please rise. We'll open the meeting by reciting the Pledge of Allegiance. And please, as you recite it, remember all those who have served and all those who are currently serving to protect this great country of ours. So if you'd cover your heart with your right hand and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. CSLB staff participating in today's meetings include Registrar David Vogt, to my left, Chief Deputy Registrar Michael Jamnetsky, over there, Legislative Chief Rebecca May, to my right, Information Technology Chief Jason Perez, and Executive Office Staff Robin Williams, who will be taking roll. In addition, we are fortunate to have with us John Kinn, Esquire, DCA Board Counsel, and Yvonne Durantes, Assistant Deputy Director, DCA Board and Bureau Relations. I understand we have representatives from the Office of Assemblymember Grayson and Assembly Business and Professions Committee. We appreciate their commitment to assisting their constituents, and we welcome them. I also understand there's television news media present as well, ABC 10 Sacramento in the back or right here. The law allows audio or video recording as long as it does not obstruct or disrupt the meeting. Slide 3. Next is agenda item B, our public comment section. This item is provided for public comment pertaining to items not on the agenda. As you are aware, today's meeting serves as a forum for the public. CSLB always welcomes and encourages public feedback. However, because this is a public meeting, the law requires us to adhere to a few rules. First, and most relevant to this meeting, if you have a pending application, pending complaint, or pending disciplinary charges before the board, please do not discuss the specific details of your case. Committee members and board counsel are not permitted to receive evidence or information outside of the administrative record in a case. This is considered ex parte communications and may jeopardize the board's investigation and enforcement efforts. The committee can receive comments regarding the complaint and enforcement process in general, or recommendations for additional consumer protections, but please refrain from providing any identifying information or facts of a particular case. CSLB greatly appreciates you adhering to this rule. Enforcement staff were present at the meeting today to meet individually with any consumers that may have complaint-related concerns. If you want to meet with staff individually, please provide your name to Katie. Where's Katie? Right there, all right. And she's not in the back room, she's at the table. Thank you, Katie. If you are participating virtually, please add your name and contact information in the chat room. You can send a confidential message to the moderator. If you have a pending complaint, it may be necessary for the assigned investigator to contact you at a later date. State law also prohibits committee members from discussing any matter brought up during public comment or acting on any item not on the agenda. If you want the committee to discuss a topic not on the agenda, you can ask the committee to consider placing that issue on the agenda of a future meeting. If your comments are related to a specific agenda item, please wait until that item comes up for discussion rather than discuss the item during the general public comment section. We will ask for public comment on each agenda item. Lastly, to allow this committee enough time to conduct its full schedule of business, public comments are limited to 3 minutes apiece. Information Technology Chief Jason Perez is our host and moderator today. He will assist us by monitoring public comment through the WebEx application. Members of the public who would like to comment at any time during the meeting, please select the raise your hand icon in the WebEx application or leave a message with the chat feature. First, I will ask if any committee members have any items they would like to place on a future meeting agenda. Any committee members present on WebEx? Seeing no additional comments from the committee members, I will now turn to general public comment for this agenda item and future agenda items. I will start with members of the public here in the room and then move to members in the public attending via WebEx. Are there any members of the public here in the room who wish to address the committee regarding items not on today's agenda or to offer an agenda item for a future meeting? Anyone in the audience? Yes, please come to the mic.
Before you get started, can you please state your name so we can accurately record your name and your comments?
Absolutely.
Thank you.
My name's Andrea Montano. My name's Andrea Montano. Is that better? Yep. Press the next button. Test, test. Okay. Thank you, everyone. Okay, my name's Andrea Montano, and I will start off by saying I have a heart condition, so public speaking sometimes can be difficult. I am here representing a wide variety of folks as an admin of a group called Scammed by Anchor Tiny Homes on Facebook. We're a collaboration of customers and employees, contractors, subcontractors, and franchise owners that have been defrauded of over $30 million and counting dollars in different varieties of ways from Anchor Tiny Homes. I'm one of the first customers that was scammed by Anchor Tiny Homes back in 2021. I do not have a case with CSLB as my case has been resolved, but I come here before you guys because I want to not only show you guys that there is so much more than what CSLB knows of, and we're hoping that we can use this platform to also help the local district attorneys, the Office of Attorney General, and local law enforcement, the FBI, IC3, and everyone that we have tried to reach out to help us. We feel like we've been on a high-speed chase for over 2 months now, and we're the only ones following the getaway car. So as you hear more about the egregious, fraudulent, embezzlement, laundering, abuse, elderly claims, and all of the stories that will come before you, whether they are complaints that are with the CSLB or people that have not come forward, there has been some major, major crimes that have happened here in our capital region, and we really hope that we can get swift action to help us all bring them to justice. Thank you for your consideration.
Thank you, Andrea.
Move on to item C.
Thank you, yeah.
We should just-
Are there any other further items not on the agenda in the audience?
They don't relate to Anchor Tiny Homes.
Yeah, and this is, again, this is not related to Anchor Tiny Homes. This is items not on the agenda. Okay, I'll be calling for comments on the item. Any on WebEx that would like to bring up any items not on the agenda?
Yes, I do have a few on WebEx. Amy Pierce, I am unmuting your line.
Okay, Amy?
California attorney. I'm a partner with Lewis Brisbois, Bisgard and Smith LLP.
We can't hear you in the large conference room.
I'm sorry? Hi, my name is Amy Pierce. I'm an attorney in California. I represent contractors in California and elsewhere. I've been working with the licensing board and contractors for more than 20 years. I would like the committee to put on its agenda an issue item in connection with a case decision that was recently issued by the Second Appellate Court. This is a Court of Appeal in Zale v. Levan. The Court of Appeal was looking at and interpreting the contractor state license law, and its interpretation of this law appears to be contradictory to positions that the Contractor State Licensing Board has taken and maintained for many years. In particular, the court interpreted the term contractor under section 7026, and there were essentially three issues that the court was addressing. One of them was whether or not if something that is installed is removable, whether a contractor's license is required. The particular context of this dispute was there was a window coverings contractor that installed more than $30,000 worth of window coverings that included motors, and the Court of Appeal endorsed the jury's finding that because these window coverings were installed with screws, they are removable and therefore no contractor's license is required. I believe this runs completely contrary to the way the licensing board views the installation of home improvement goods. As we all know, most items that get installed are not permanent. They are removable. People often do home remodeling projects. The Court of Appeal somewhat disregarded that the licensing board has included in its classifications a C61 D52 classification for window coverings contractors, among other classifications that covered the scopes of work that were at issue here. One of the other issues that I think is important for the licensing board is the appellate court appeared to endorse the idea that an unlicensed contractor could direct the home, could solicit bids, solicit contractors, review the bids, review the work, and if they directed the homeowner to pay the subcontractor directly, pay the unlicensed contractors directly, that this somehow made these subcontractors and these contractors the homeowners contractors as opposed to the unlicensed contractors, subcontractors. One of the other issues that I think is troubling in this day and age is that Ms. Zale referred to herself as a interior decorator. Because she didn't call herself a contractor or a subcontractor, the court was very lenient in the way that it referred to the supervisory work that she did.
Okay, thank you, Amy.
Bids.
Thank you for your request. The board consider a future agenda item. Please place this request in writing addressed to Board Chair Michael Mark and mailed to CSLB Headquarters Executive Office, and it will be reviewed and considered.
Thank you so much.
Thank you. Do we have anyone else on WebEx? Jason?
Yes, I am unmuting Kathy Nguyen.
Okay, Kathy.
Go ahead, Kathy. We show her mic unmuted. Hello, Kathy. We're not able to hear you if you are speaking.
Hi, can you hear me?
Yes, we can. Go ahead.
Okay. I think just the request that we had was, I know we know that California had recently had grants for ADUs in the past couple of years. We were thinking that possibly in the future, if there are going to be grants that are going to be made available, if there's something that, this situation could have, I guess, a priority or a notice so that we can apply for this grant to possibly help us with the restitution.
Okay, thank you, Kathy.
Sorry, I'm not sure if you guys got all that.
Thank you.
All right, thank you,
Okay,
Kathy.
thank you.
For your request, the board consider a future agenda item. Please place this request in writing addressed to Board Chair Michael Mark and mail it to CSLB Headquarters Executive Office, and it will be reviewed and considered. Jason, do we have anyone else?
Yes, we have Vivian Wong. Unmuting your line right now. Go ahead.
And I have a swimming pool complaint that this is the second go around, and the first part of it was last year. The contractor was resolved through arbitration, and now is the second contractor doing the repairs has abandoned the project, and the board is in the process of trying to close out the case, and I need your help to evaluate this more thoroughly because the industry expert that the board provided gave an estimate. and
Ms. Wong?
it wasn't-
This is John Kinn, counsel for the board. We'd rather you not explain your specifics of a pending complaint because only a part of the board is here today and they can't hear specifics of ongoing complaints. If you'd like, I think there's
Contact her in the chat room.
yeah, if you put your contact information in the chat room, someone from enforcement can get in touch with you and discuss your case and the specifics.
Okay, I just want the board to not close out the case, and for future, a contractor that is license suspended, what is the procedure in terms of filing a complaint? Because had to wait for that. And then when the industry expert provide numbers, there's no justification, line items of what it includes. So just want more transparency to help to protect us as the consumers.
Thank you. And you can discuss your specifics with the enforcement staff.
All right, thank you.
All right, thank you. And John, would it be more appropriate for tomorrow her to speak during general comment or not, just a comment with her educator?
Yeah.
We need her to talk to the investigator, the supervisor.
Okay.
Yeah.
All right, thank you. Do we have anyone else on WebEx?
Yes, we do. We have Richard Markinson. I unmuted
Good
your
afternoon,
line.
Board. It's Richard Markinson, representing the Western Electrical Contractors Association, the Plumbing, Heating, Cooling Contractors of California, and the American Fire Sprinkler Association, and the Independent Roofing Contractors of California. With the enactment of AB 2622 by Assemblymember Carrillo, which deregulates construction projects under $1,000 from the purview, I'm paraphrasing, of the CSLB. But from the perspective of my clients, this bill, because it only modified Business and Professions Code 7048, created a variety of loopholes in other B&P code sections that are applicable to licensed contractors. For instance, 7090, 7152.2, and others that trigger a variety of requirements and obligations for contractors for projects above $500. So my clients would like to suggest that the CSLB consider proposing possibly for the omnibus business professions bill next year, legislation that would correct these inconsistencies and bring into comedy or similar language for licensed contractors and unlicensed construction workers, so that there is not an unlevel playing field that completely ignores any work by an unlicensed contractor of under $1,000, yet subjects a licensed contractor to a variety of requirements and obligations for contracts between $500 and $1,000. So that's my request. I'll be happy to put that in writing and share it with the chair. And thank you very much for your service to consumers and contractors, and for allowing me to share my clients' perspectives.
I appreciate that, sir. And yeah, if you would send that request in writing and then also reach out to our legislative director, Rebecca May, to my right, that would be greatly appreciated. All right, thank you. Do we have anyone else on WebEx?
Yes, we do. We have Connie Arnold. I am unmuting your line. Go ahead.
Can you hear me?
Yes, we can.
Oh, okay, thank you. Thank you very much for the opportunity to speak. My name is Connie Arnold. I'm a disability rights advocate, and I just had some comments regarding items not on the agenda, as well as the item related to the accessory dwelling units. And first off, I wanted to say I find it problematic that Find My Contractor does not have any category for specialization of individuals who specialize in residential home renovations for persons with disabilities, such as roll-in showers and things like that. I understand that all contractors are supposed to know these things, but some individuals do specialize in that. Additionally, as it relates to the proposal concerning the accessory dwelling units, I'm very concerned about anything that would require a bond and a payment of that for homeowners with disabilities and families with disabilities that are trying to keep their loved one on the property with them for aging in place, because that will make it more cost prohibitive for such individuals to undertake accessory dwelling units. Let's see, I had one more comment, which was that the government code 4459 that says that the division of the state architect has to maintain building codes that don't increase or enhance accessibility needs to be changed, because there is so much technological innovation happening, including building situations like glamping for like camping, that sites that are not accessible, zip lining accessibility, because that can be made accessible, electric charging stations requiring access for persons possibly with disabilities. And the codes are not such that it addresses any enhancement or increase in access other than maintaining our existing Title 24 codes and building standards, and not doing less than minimum standards in the ADA. That's problematic. I'd like to see that addressed in legislation. And I'd be happy to talk to anybody after the meeting. I'm going to put my information, my phone number, and my email in the Q&A box. Thank you very much.
All right, thank you for that request. If you put that in writing and send it to the chair, Michael Mark, here at the headquarters, CSLB headquarters, we'd, greatly appreciate that. Anyone else on WebEx?
Can somebody put the address in?
We're going to keep track of all this that relates to ADU, so they wouldn't need to send it.
Okay.
We'll be.
All right, thank you.
Thank you.
Anyone else? Jason?
We have no one else
It
at this
doesn't
time.
relate to ADU.
Okay, thank you very much. We'll end that portion and, yes, is this something not on the agenda?
Yes. Good afternoon. My name is Can you guys hear me? Good afternoon. My name is Carlos Lupiano. I'm here on behalf of my dad, Armando Martinez. He owns MC Construction. And I wanted to tell the board if we could, I have some concerns on subcontractors who lack protection on contractors not paying us. We were owed money by a builder. And so we wanted a protection for subcontractors. Because the other route to go was to put liens on people's properties, and that's not fair to the property owners who've paid the general contractor. So I would like to more protection for subcontractors. Thank you.
Yeah, we appreciate that. We will be looking into that. Appreciate your comment. All right, anyone else from the audience? All right, so now we are now moving on to agenda item C. At today's meeting, the committee is looking for feedback from the public regarding laws applicable to licensed contractors engaging in residential construction, whether that is home improvement or the construction of single-family dwellings. I will now turn it over to Registrar David Folk to explain the board's role in protecting consumers through the home improvement business contractors laws, and to provide background information on some legislative concepts identified by staff. David?
Thank you, Chair Barton. And I want to thank all of you for attending the meeting today. I know that you're attending this meeting because you do have a complaint against a licensed contractor that has not completed your projects. That's what we're hearing. Has taken significant amounts of money and failed to complete the contract, which is very troubling. I just want to lead by stating that public protection is highest priority of this board. And so we really look forward to hearing about your suggestions. If we have legislative improvements, we want to consider them. We have staff here that will be taking note of your suggestions, so you won't need to put those in writing. We should be able to capture that at the meeting today. What I wanted to do, though, to begin with, is just provide some background information. If we could turn to the next slide. And the next slide, please. When we talk about accessory dwelling units, they can be either a conversion of a garage into a living quarters. It could be an attic, it could become an apartment. But I think most of you are here today because you've contracted for what we'll call ADUs in a residentially zoned area to put an ADU on property that you own. It's not directly connected to the existing structure. I think that's probably a true statement. Next slide, please. I mention that because our board takes very seriously home improvement payment restrictions. In California, if you're a contractor and you're performing home improvement work, you're restricted to not receiving, you get a $1,000 deposit, nothing greater than that, but you're restricted to not receiving payments that are greater than the value of work and material supply. We have a slide that covers that. Now, if you look at 7164, this statute relates to new home construction. At some point, the legislature created this statute, and they must have taken the position that if you're building a new home, that you don't need the same protection that you would need if you're remodeling an existing structure, because 7164 doesn't restrict payments. You could pay your contractor 100% up front if it's for a new home construction. And after we've received complaints, we have looked into building department requirements, and we understand that many building departments consider ADUs to be new construction. So there may well be a need to clarify that an ADU is not construction. I know we have some staff that are watching this meeting today. I want to reference a government code that clearly states that an ADU is a living facility that's attached to or detached on the same property is considered to be home improvement. We do consider it administratively as home improvement. And I'm going to show you in a minute why that's important. Now, one of the lead-ins on this, and if you looked at, I'm sure you looked at the agenda, is whether we need to clarify in law that an ADU that's not directly connected to an existing structure is home improvement. Probably do need to do that because there is confusion, and if you're to file a case criminally, we may need that clarification. We do not believe we need it administratively to hold a contractor accountable for violating administrative law. So can we turn to the next slide? This is a very important slide because, as I mentioned previously, in California, you're granting credit to your customer, to your homeowner. The idea is you can get a $1,000 deposit, but if you're not going to get paid until the completion of the job, then the payments cannot be greater than the work that's being paid for. And I know that many of you here have made a second or third payment for a significant amount of money, sometimes for plans that you don't have, maybe for a permit and some type of fees that you don't know were paid. That's a problem. This law kicks in, and that's why we need to be clear that ADUs in residentially zoned areas are considered home improvement. Now, a contractor can take 100% up front if they have what's known as a payment and performance bond. Very few contractors have that, and the contractor that you've contracted with did not have a payment and performance bond. So let's move on to the next slide. Here I just I want to emphasize that the Contractors Board has administrative authority. We establish qualifications for licensees. We have the ability to administratively take disciplinary action against a contractor's license, and that often includes the revocation of the license. That's what we can do at the Contractors Board. We can take administrative action. Now, when you look at violation of payments, you look at abandonment, not completing the contract, but were funds misused. Did you pay money to a contractor and that money went elsewhere? It didn't go towards your project. It's misuse of funds. Do you have sufficient funds left in your contract to complete your contract? Many of you do not. That's all grounds for revocation of the license administratively. Now, turn to the next slide. Criminally, and that's why we need to be a little bit careful today, I think as Chair Barton pointed out or mentioned, we do have enforcement staff here because violations that can be addressed administratively often can also be addressed or referred to a local prosecutor, that being a district attorney, for criminal prosecution. And we cannot be discussing an investigation that may result in a referral to a district attorney because we do not want to compromise it. So when you think about making your comments today, I would ask that you do so in a general sense. You look for opportunities maybe to help us to support legislation that could better protect consumers in the future, could tighten up the laws. But if you want to talk about your specific case or you have a concern that it's not being publicly disclosed, you would want to discuss that with enforcement staff separate from this public meeting. So we are prepared to open that avenue for you. Okay, next slide, please. I included this slide because in the event you have a contractor that has filed for bankruptcy or may file for bankruptcy, this could be helpful. 484B is the penal code statute that is most commonly investigated here at the Contractors Board. What it says is that if a contractor requested and received money for a specific construction purpose and it went elsewhere, it didn't go towards that purpose, that would constitute a violation of 484B. So you need to be aware of that. We're not able to discuss, or give legal advice or certainly discuss bankruptcy law here, but in the event that you would like information regarding bankruptcy, I went to the internet and I found a really interesting document. It's called Bankruptcy Basics. So you could look at that. It has a lot of information that discusses the federal bankruptcy code. But this would be a section of law that will be investigated, that is investigated by the Contractors Board when we receive complaints that people have paid money for specific construction projects and it didn't go towards that project. Next slide. So this is one. When you look at this slide, and I'll be honest with you, this was educational to me yesterday when Mike Jemnetsky brought to my attention that if you look at the bonding requirements for a limited liability company, what you'll see is that limited liability companies have additional bonding requirements. Every contractor is required to have a $25,000 bond. Now, limited liability companies are required to have an additional $100,000 bond, but it's limited to employees and workers. How does that help you as a consumer? I mean, that's something we ought to really take a look at, I think. Why isn't the consumer, first and foremost, someone that could try to collect on that bond? And then liability insurance, that's not going to help. It's been our experience that it won't help when someone's taking money not performed. If they cause damage, what we call secondary damage to your house, the liability insurance could be beneficial. But should this be looked at? Should this be tightened up? Perhaps. Next slide. And again, these are just concepts that staff here at the Contractors Board have come up with for your consideration. You may have different ideas, you may have better ideas, and that's what we want to hear this afternoon. This slide just shows, it provides a description of different bonds. We have what we call payment and performance bonds. The law already says, encourages consumers and contractors to get a payment and performance bond when a contractor is taking progress payments. How are they helpful? Well, a payment bond ensures subcontractors are paid. The performance bond ensures that it's completed per the contract specifications. Now, why are they not very popular? Because it's been our experience that they add 2 to 4% to the contract price. So if you're entering into a contract to build a $200,000 ADU, do you want to spend $8,000 on a payment and performance bond? Probably not. But that's why we don't see a lot of those being obtained today. We're almost through this slideshow, so one more. Next slide, please. Now, many states have recovery funds. Recovery fund is where licensed contractors pay in upon their renewing their license into this fund. It could cost them on renewal. I've reached out to a couple of other states to find out how much the licensees have to pay, and it's approximately $300 every 2 years. But you could establish a recovery fund. Why do we not have a recovery fund in California today? In large part because we have around 245,000 licensed contractors, and they would rather not have to pay additional money on the renewal. It's kind of a philosophical question. The majority of contractors do a great job. They don't take money and fail to perform the work. And what you have are the good contractors then paying for a few of the bad. But I can tell you that other states do have recovery funds, and it does provide an avenue for a consumer to seek legislation, or seek restitution, excuse me. So go to the next slide. I think it's the last one. And this is where we really do welcome any ideas that you have, any comments on what we just discussed. And if you have any additional ideas, we look forward to hearing them.
Okay. Thank you, Registrar Folk. I would now like to open this agenda item up for discussion by the committee members. Are there any comments or questions regarding the ideas already offered or any other possible ideas? I will start with committee members in the room. Any? All right, how about on WebEx? Any committee members? Okay, seeing no additional comments by the committee members,
sorry.
I will now. Do we
Chair,
have?
Barton, we do have a public comment on WebEx.
Go ahead, Mark. Is that Mark?
Perez. Joseph, go ahead.
Is that a board member? No. Oh, okay. Let me finish this as a general comment or general public. So I want to address the members in the room first. So I'll turn it over to those members of the public here in the room who wish to address the committee regarding this agenda item. Anyone, please step up to the podium.
Test, test. Thank you again. Andrea Montano. In regards to this agenda item, I would say one of the items that was suggested is perhaps a proportional to the concurrent liability would be suffice for surety bonds instead of raising it from a $25K to another minimum amount, being that there are some mom and pop small businesses, remodeling companies that are not necessarily working in large volumes, and that could detrimentally hurt those businesses. But for these larger companies that are franchising and they're carrying multiple millions of liability concurrently, perhaps carrying a surety bond that is proportional to that would be suffice, and having potential periodic reviews of those financials to make sure that they meet those That would be a recommendation from our group. And then something that wasn't mentioned, I'm not sure if this is in a later agenda item, but more protection around financing laws, whereas construction loans typically are held in escrow, and those payments are being monitored by a third party. We're with HELOC and sometimes other type of loans that are taken out for these types of projects. The monies are handed over to the consumers directly, and sometimes they don't have the means or the know-how or the legal remedy to trust that when they're handing over these funds to the contractor, they think they're doing the right thing. They think they're doing what they're supposed to be doing. And so maybe tightening up some financing laws to help consumers now that are taking out ADU loans, that are borrowing against their 401ks, to help protect them in the future. Thank you.
Thank you very much for that. Anyone else in the audience? All right, thank you. Anyone on WebEx?
Yes, we have Joseph Retz. Your line is unmuted.
Hi, guys. Joseph Perez, owner, general contractor of Neo Builders. We're a small ADU company that's building 15 to 20 ADUs a year. There are a lot of good ADU contractors. I think if we put payment bonds or performance bonds on every single ADU, that would definitely solve this problem. But it is very, very expensive. And most small contractors or medium-sized contractors will not be able to, number one, even apply for these payment and performance bonds. It's just too hard. They want so much financials. So I think it would be a really, really bad option. I do think that the fund that you guys were talking about is a good option. Maybe it comes from the contractors that are building ADUs. For example, taxing on another $100 per permit that is pulled for an ADU in each city or in each state. That might work out well. But I really do think that there are a lot of contractors that really want to make their entire business building housing and building ADUs, like me. And I think a good option for those people is doing a different license, for example, a C license or a D license that specifically are for ADUs. And then if you guys want to put easier terms, for example, on different bonds, or make it more challenging to take on way too many ADUs under that license, that is a good option. Or even make like the performance bonds or different bonds easier for that license. I think that's a really good option. But a secondary license for ADU contractors specifically will make it more challenging to jump in the game and have a ton of money and a ton of marketing and basically scam homeowners into saying like, I built so many ADUs. Like, let's get a license specifically for ADUs. Yes, sir.
All right, thank you very much. Do we have anyone else on WebEx, Jason?
Yes, we have Christopher Peterson.
Christopher?
Hello, yes. Can you hear me okay?
Yes, we can.
Yes, I'd like to address briefly, there appears to be a point where homeowners can be in double jeopardy where they have paid their contractor and then they have liens against their house for the construction, but the people filing the liens never get paid. I was wondering if it'd be worth considering for large payments on large projects that go to a contractor, if those could be put into an escrow account and the contractors performing safe foundation work would put the lien against that escrow account instead of against the homeowner.
That's a good idea. Thank you for that suggestion. Is there anyone else on WebEx?
Yes, we have Douglas Washburn. Go ahead.
Yeah, I'm sorry, I can't quite hear everything here because of my hearing aid setup. But I wanted to follow up on the financial ideas that were previously raised. Um, After a illegal demand for a billing of advance money before work is performed, a consumer coming to the um, the bank to uh, raise a fraud claim gets the pushback saying, oh, that was an ACH transfer, which was authorized by you. And they promptly close it without any investigation into the details of whether it was fraudulently billed. Um, there should be some analysis and legislation around the banking industry and how disputes against this, also with respect to the 60-day rule versus 90-day kinds of rules for putting a claim against an ACH payment, needs to be rethought and probably legislated, because often the determination that it was fraudulent comes much later. Naive homeowners don't know all the ins and outs of these laws and rules, and then they seem to have no legal recourse against clawing back money from a contractor gone bad and off the rails. Thank you.
Thank you for that. Jason, anyone else on WebEx?
Yes, we have a Jared Bassler.
Jared?
Looks like we lost his audio. He lost his mic. We will return back to you, Jared, if you can address your mic issue. We'll go to Janine Carroll. Go ahead, Janine.
Hello.
Hello, we can hear you.
Okay, great. I have a couple comments, so bear with me if you would. Number one, just on the criminal matters, has the board referred anchored to the district attorney's office?
Could you repeat that? I couldn't quite hear that.
Sure. Has the board, have you guys referred anchored to the district attorney's office?
The legislative committee is not at liberty to discuss ongoing investigations. So I know it sounds like it's a little evasive, but it's not. It's to protect folks like you making complaints, not having your names out in the public. And I think Registrar Vogt said, and if he didn't, I'll say it, the CSLB is working with law enforcement on this issue and regularly cooperates with law enforcement on these types of investigations.
Okay, that's fair. I wanted to support the subcontractor who spoke. It is a double penalty. It's a double penalty for the homeowner, actually, when the general contractor screws the subcontractor, because the homeowner pays the contractor and then pays again. There's a huge problem there that has to be addressed, because there are all of these homeowners who are paying double. And the subcontractor, the ones who don't want to file liens, and they should file liens because they should get paid, but it shouldn't be the penalty of the homeowner. I cannot understand that for the life of me. And another comment I have about the insurance, I understand that there was a surety bond here. And, we give people 30 days, even though, they've been very deceptive. We give them 30 days to cancel that. I honestly feel that this is a board that's supposed to protect the public. And I feel like it was so slow doing that people lost a boatload of money in July and in June. And there was plenty of notice given by that point that something should have been done. There are homeowners who have lost money, and to me, it's just inexplicable that it took this long to uncover the fraud. I say fraud. I understand you don't want to say it. I say it, but thanks for hearing my comments. And I think, you have to figure out a better way if you're truly going to protect the public.
Yeah, we greatly appreciate that. Anyone else on WebEx, Jason?
Yes, we have Katie Lucas. Go ahead, Katie.
Thank you. I wanted to speak on the fact that I feel like we found ourselves in this situation because of the lack of communication between the customer and our subcontractors. And I feel like if there was a law put in place where after 30 days of the subcontractor not being paid, they can communicate that or are made to communicate that with the homeowner. That way they can come to a quicker agreement or a quicker realization of who needs to be paid and why this happened, because so many months go on without the communication between the subcontractor and the homeowner. And I just think that that is something that needs to be changed.
Thank you very much.
And thank you.
Jason, do we have anyone else on WebEx?
Yes, we do. Laura Zanucci, I am unmuting your line. Go ahead.
Laura Zanzuki. I'm a homeowner. I'm an individual that was scammed by Anchor Tiny Homes for $40,000. I'm affected by all the issues discussed today. I appreciate you opening this forum for us to make comments. There's a few comments I want to make. Regarding the bond, the current bond regulations do not address the level of liability a large-scale company like Anchor Tiny Homes holds. The laws regulating this are insufficient and offer no solution for homeowners and other affected parties when a company engages in this type of long-term fraud. I respect the contractor's opinion. I don't think that every contractor's bond should be increased. I do agree with Andrea in saying that I believe there should be some equitability in terms of if you're taking on a huge liability, you're trying to sign up hundreds of customers and you say you have a financial stability of $100 million, that bond should not be $25,000. I work as a therapist, and when I opened my telehealth private practice, I had to have liability insurance to the tune of $1 million. So, and the thing is that my liability with one or two clients providing therapy online is essentially a data breach, right? And so I don't even have them in person. But to me, I cannot understand this bond law at all. I like a lot of the suggestions being proposed around I guess it was a contractor suggesting a separate licensing for ADU builders. That sounds promising. I hadn't heard of that before. And that's certainly with the restrictions that they're monitored more closely in terms of the contracts they take on, right? And I think they mentioned the marketing too. Marketing has to reflect what you're providing. So I appreciate you bringing up the bond issue. I do want to speak really quickly to recovery funds. Due to the bond issue and due to insufficient banking response, of course, there's people out $100 million and we're just trying to find ways to even recapture 10% of that. I'm sensitive to the fact that new contractors renewing their license should not take on that burden to fund that. But so if there's any other way to do it, to make it more equitable to the contractors involved, but I do think there needs to be a recovery fund. I also represent the Facebook group Scammed by Anchor Tiny Homes, and I did a poll of those members. It's about 1,000 of us, and recovery fund was the top issue, second to that prosecution.
All right, well, thank you very much.
Okay, thank you.
All right, and we have anyone else on WebEx?
Yes, we have Jason Comerford. Your line is unmuted.
Appreciate everyone's time here today. Specifically, I want to address the question regarding making subcontractors and or material suppliers responsible parties in the necessitating payment from primary contractors. One of the biggest things that I've noticed throughout this entire process of my being scammed by Anchor Tiny Homes as well a significant period of time beyond their normal payment terms when they had invoices that were outstanding and past due, yet would continue to work, which generated some of the additional cost for many individuals. Specifically, a wood material supplier for my project ended up attaching a lien to my property, and their standard practice was they accepted that they would be paid 30 days past due and then trailing down to 60 days past due with their invoices. So they're accepting risk in the sense that, they're allowing individuals, if you're in a payment practice and your debtor doesn't pay you until you're past due for a certain period of time, you have to accept that there's risk associated with that. But to them, they did not accept any risk because they attached liens for every single one of those entities, those projects. What risk or responsibility is supposed to be borne by the subcontractor or material supplier for continuing to supply and or do work for an individual that has not paid them for a significant period of time? That being said, it's simply, if they're accepting risk of non-payment for doing work, that transparency should be borne somewhat the risk by the subcontractor, not only the homeowner.
Thank you, Jason.
I appreciate it.
Is there anyone else on WebEx?
Yes, we have Sydney Brown.
Okay, Sydney.
Go ahead, Sydney.
I'm Sydney's wife. We're both in this with the whole issue with Anchor Tiny Homes. My name's Kate Brolin. And one of the things, I really appreciate you having this, but this is part of the meeting today on the agenda. But one of the things that we have run into, and I hate to say this to the contractors on board, but because we also had a previous issue with another contractor, and I'll just say the protocol or the system of trying to file a complaint I felt was quite arduous, and I work with a lot of paperwork, but I felt like we were almost questioned more than maybe Anchored Tiny Home, or in this case, another person who actually had a fake contractor's license, which we didn't know, but the CSLB, the board, they took so long, they took over a year to get back to us just to tell us on that one, oh no, we can't take this because he never had a license in the first place. So anyway, but the other part of this is how a consumer can be walked through and supported. As I read a lot on the Facebook website for Scam by Anchor, I would read a lot of people who I think were having such a challenge, either trying to get attached onto that bond, which I guess is not going to appear, and the time frame of how long. I mean, I don't understand why the board did not get how bad this was. I mean, I'll just say we were injured long ago, like way back in February, March. And we contacted the board. it took us so long to get this process through. And then finally, the very nice young woman who was helping us, she said, oh my God, now we've had so many calls, you know, she was pushing it through. But I just want to mention that protocol. Don't wait till kind of the shit hits the fan. I mean, I think you need to believe the consumer first. Thank you.
Well, thank you for that. With no objections, we'll take like a 15-minute break so we can compile all the suggestions. I appreciate everyone coming, and I know I speak for the whole entire board because I read every document that was sent for this issue. I reviewed every news clip, and I appreciate media for calling this out and putting so many clips, but it distressed me greatly, and I know the rest of the board is distressed greatly by this issue also. So appreciate all the suggestions. We will definitely take those to task, and I'll report back in 15 minutes if that's okay.
And before we go off the record, I just wanted to clarify that you're speaking on behalf of the committee here today. So when you use the word board, it's truly the committee that today is considering these things.
Thank you for that.
And one other note, to the extent folks are considering bankruptcy remedies or considering payments and performance bonds, we as a committee, and I'm sure as a board, strongly recommend you get your own legal counsel. Start with self-help, but go find a lawyer that you trust. Thanks.
All right, we'll adjourn for 15 minutes. We'll reconvene at 2:15. Thank you. Again?
Yes, I am back.
Four more comments.
Are we ready for additional public comments? We still have about 4 more.
Yeah, I'd like to call this meeting back to order. We'll reconvene. And again, the committee thanks all the public for showing up. And as stated and corrected by legal, thank you, legal, that it is a committee that's distressed by all that's going on. And again, we appreciate the media for covering this to bring it to light. And we appreciate everyone showing up in person as well as WebEx. So we'll continue, and then we'll end up too, if anybody in the, actually what I'd like to do is summarize everything, and if Registrar Folk would summarize everything that we've heard so far and things that we'll look into, and then we'll continue with WebEx. Registrar Folk.
Yeah, thank you, Chair Barton. I would like to summarize what I have learned from all of you this afternoon, and if it's incorrect, please provide additional information or correct what I understood was said. The first thing we talked a lot about financial laws, and we may need to look at why banks are not requiring escrow accounts today. If you go back 10, 15 years ago, the banks would have an escrow officer. They'd actually go out to the job site. They would look and see if the work was done before they would authorize payment for that work, and you're just not seeing it currently. What financial oversight exists where the banks are, in some situations, maybe paying the contractors directly. I don't know that happened here, but we see it in other situations where the banks pay the contractor directly, and that puts the consumer at considerable risk if the contractor doesn't do the work. But for perhaps some of the complaints that have been received in this situation, the contractor was paid by a homeowner that did get a loan, the loan proceeds, and was not provided the information they really need to protect themselves and not turning that money over to the contractor, something we want to look at. We will explore recovery funds, look at what other states have, whether that's viable. It probably will require a construction industry meeting. That's a public meeting where we'd get input from the construction industry as to what opposition they would have for a recovery fund. The CSLB is not in the bond business. We're not a surety company. We do require bonds, as I mentioned earlier. We will ask the surety companies to meet with us. We heard a lot about having a bond that would be equivalent to the amount of work that's being done, that would provide a lot of protection. Where would the surety companies fall on that? We do have a direct relationship with surety companies here, although, again, we're not a surety company, but we'll ask them what is their position on increasing surety bonds? What would be the cost for that? We heard there might be a benefit in requiring a specific license for an ADU. So that's something our license or examination unit will be asked to consider. We heard a lot about mechanic liens and subcontractors that may be unpaid, puts the consumer at risk when the prime contractor was paid for the work done by the subcontractor or those materials supplied. Consumer could result in a consumer having to pay twice. So that's an issue. I would mention, though, that on the CSLB website, we do have mechanic lien information. The mechanic lien law is in the California Constitution. And I know you have a Facebook page, and I think there's information on our website that could be very helpful if you want to consider that, for your Facebook page or just so that you're aware of it. We talked about investigations, and our goal is to perform our investigations timely, and just want to emphasize that we appreciate the public and consumers, especially filing complaints so that we can effectively regulate the construction industry. So it's our goal to be professional and to really appreciate a complaint being filed when somebody's been harmed by a contractor. And just in closing, I want to just clarify something I said earlier. I cut off what I think I really needed to emphasize, and that is regarding the payment schedule and an ADU that's on a residential property being considered home improvement. If you look at the CSLB definition of home improvement, it includes all improvement on or adjacent to a dwelling, to a house. That's similar to a swimming pool. It's not directly attached to the house, but it's still considered home improvement. That's why an ADU is considered home improvement. I do think that we need to clarify the definition of home improvement to make it very clear that an ADU is considered home improvement. We had to do that and declare disaster areas. We wanted the reconstruction in those areas to be for those consumers to be protected by the payment restrictions. So we added to the definition of home improvement that it includes reconstruction and declared disaster areas. So that's what we have so far. I know we have some more comments. If there's anything you'd like to add to it or clarify, please do so. And it's back to you, Chair Barton.
Thank you, Registrar Fogg. Back to the WebEx, do we have any comments on the agenda?
Yes. I am unmuting John Arenson. Go ahead, John.
Yeah, can you hear me?
Yes, if you can just speak close to the mic, that would be good.
All right. Yeah, I like the idea of being a double-edged contractor myself. I hold multiple contractors licenses and have for decades. I do like that idea because it does bring you closer to home with your particular niche as an expert or a specialist in a given field. My only concern would that be incumbent then upon let's say I'm a general contractor, which I am, and I'm also a C47, which is manufactured home, but now you develop this other niche or this other classification. Would I then have to, because I've already been in this industry for almost 40 years, would I then have to qualify for this license as well? I know I had to take a special test for my C47. Not that I would mind. I don't mind doing that at all. In fact, my other question for you folks was, I'm also a licensed real estate broker. I'm a licensed DMV tiny home and park model dealer. And I'm a licensed HCD manufactured home dealer. And in every single one of those fields, every 2 to 4 years, we have to requalify by going through an arduous retraining program. I've yet to see, I've always wondered why the Contractors License Board doesn't place those same demands on its contractors. I definitely think there's a need for contractors, just as there is real estate brokers or anybody else that holds a state license, to get requalified. But I've never, ever seen that, and it's always baffled me.
Well, okay, thank you for that. Anything else on WebEx? Do you have another comment?
Yes, we have Maria and Leo. Your line is unmuted. Go ahead.
This is Leo. I just had a couple points, but I also, John, the gentleman who spoke before me, made a good comment. First, about the bond. So if we do the bond for each ADU, what I think we need to take into consideration is that a bond is something you deal with after something happens, not before something happens. And I think we need to focus a little bit more on preventing rather than dealing with the aftermath. Where my wife and I fell victim to this was the whole fund control. Now that we look back, I'm thinking, why does the contractor have access to this fund control thing? It should be completely separate from the contractor. And I could be wrong. This could be a normal thing. This is something new to us as well. But in any case, my idea was take the fund control factor away from the contractor and give it to a private entity.
Okay, thank you very much. Do we have another comment on WebEx?
Yes, we have Ryan. Your line is unmuted.
Hello, my name is Ryan O'Connell, and I represent How to ADU, which is a Facebook community with over 90,000 California homeowners all trying to build ADUs. I think when you guys are considering all this, and it's great that you're taking the complaints seriously of all these homeowners, I would just give a little bit of thought on the framework for how you think about the potential solutions that you're considering. I'd say that the system works well 100 plus times a day with the number of ADU permits that are getting entitled and getting built. So we should make sure that the solution we come up with doesn't harm the happy path projects more than it helps the unhappy path projects. I mean, it's a huge tragedy on an individual level, and I want to make things better for the people who got wronged here, but I also want to preserve the industry and regulation in general, like requiring separate licensing or specialized licensing is going to increase the cost, decrease the amount of providers, et cetera. And then the other thing I'd say is whatever solutions you're considering, would those solutions have saved the homeowners in this alleged Anchored situation? Because if Anchored had gone ahead let's assume that, I'll take it off Anchored. If a bad operator wants to get a specialized license or whatever other requirements we put in front of them, or simply operate with the wrong license or unlicensed, they'll still be able to swindle a lot of people. And it's going to be tough. It's going to be tough to help anybody in that situation. Having said that, I find the solutions really interesting. The definition between residential, home improvement, and other classifications is a really good path to go down. I think financial oversight is tough with all the cash deals and HELOCs that happen in this ADU space right now in this economy, but that's another interesting angle. And then in terms of recovery,
Your time
funds,
is
I
up.
encourage the CSLB to talk to CalHFA about potentially looking at how they did manage construction escrow for the grant that was administered last year. Thank you.
All right, thank you so much for your comment. Do we have anyone else on WebEx?
Yes, Mark Allen, unmuted your line. Go ahead.
Were victimized by the Anchor Tiny Home. I have a question for the CSLB, and it may not be directly related to the agenda items, but I think there's an adjacency to it. And my question is, how does the CSLB police bad actors? A contractor who gets a CSLB license, starts a business, they go under, and then, they turn around and open up another business. What is the CSLB doing about ensuring that bad actors don't keep on playing roulette with different licenses?
Okay. Yeah, thank you for that. Put your information in the chat room, and we'll be sure to get back to you. I know we have.
Yeah, because this is not a dialogue. Stick it in.
Yeah, thank you for that. I know we have officers. In fact, I unfortunately didn't get to see them today. They're graduating enforcement officers that go out and police projects. So thank you for that. Do we have anything else in WebEx?
Yes, we have a N. Rowland. Your line is unmuted. Go ahead.
Can you hear me?
Yes, we can.
Hi, thank you. Thank you for having this meeting. My family, we were all trying to do a wonderful thing for my mother, and we were going in together to build an ADU on our property to take care of her. She's 85 years old, disabled, and we also have a disabled son, and we thought maybe in the future we could, use this small ADU to help others. And I think many of the people who were defrauded here, it's all the same story. And we were paying as per our contract told us to. We trusted our salesmen. We trusted this company. We checked the Better Business Bureau. We checked Yelp. We checked Google. We looked at the Contractors License Board. Everything looked good. I think after losing over $90,000 in this endeavor, we would have appreciated if the CSLB had a very easy step-by-step tip sheet for ordinary folks. Your website is pretty in-depth on many things, but there was nothing there for us really to make this simple. One good example I came up with as I've been listening to all of this is that our contract, apparently, according to y'all today, it was not a proper contract. It seemed like we were paying ahead of schedule. And had we known that this contract was having us pay so much more up front than we were supposed to, we would have never, signed for that. And so my suggestion is, number one, is to have a law that these companies must follow a certain contract. and then make that very plain and clear on your website, that this is what a contract should look like. When you get into, negotiation for this contract, it should show this, this, and this. And we would have appreciated that very much. John also, another speaker earlier said trainings. I found out after the fact that several of the employees of this company saw the writing on the wall. There should be encouragement for whistleblowers. We would not have paid all of these extra payments had the whistle blown earlier that this company was in trouble and they were spending our money that we were paying them on other things that had nothing to do with our projects. So, and then lastly, I wanted to just mention about a lawyer. You mentioned earlier that we should find a bankruptcy lawyer and talk to a lawyer and
You have 10 seconds.
A lawyer is $5,000. I contacted 2 lawyers and we don't have another $5,000. We had to start our permitting process and pay an extra $5,000 for our permitting. Even though we had already paid for permitting, we had to do it over again. We don't have $5,000 for a retainer.
Your time is up.
So I want to thank you again, and hopefully we all can come to some solutions here.
No, thank you very much for that comment. We were talking about that very issue with Legislative Chief May and myself today. We as a committee and a board need to do more to get the word out there and to protect the consumer. So I really appreciate that comment. Do we have another one on WebEx?
Yes, unmuting line for Beto. User Beto, is your request, we requested your line to be unmuted. Okay, while they're working through that, we have another one, Mike. Go ahead, Mike.
Can you hear me okay?
Yes.
Yes, I've been listening to all of these cases or the comments here for a while here, and I'd like to throw this in as a contribution. We actually had a case with a contractor who warned us after the situation was going bad that the CSLB was a toothless tiger and that, he was going to be able to get around anything we did, which only motivated us to pursue this harder. We actually ended up getting an assembly person involved, and that person actually ended up getting CSLB to reopen our cases after CSLB had closed our cases. They would not reopen all the victims that we had. We had over 85 victims, but they did take on our 3 of us, and one of us, myself, had 2 cases. The damages were over $400,000. We went through the process of going through the CSLB court system, which is a specialized court system where the AG's office represents the CSLB, and we are actually witnesses in the case against the contractor. So it's not something where they're representing us. They're just going against the contractor from CSLB standpoint with the goal of making a recommendation to the courtroom. At the end, we got the license revoked. The problem is over $400,000 of damages were caused, and all he got was a 3-year revocation. We're really not sure, and we don't have any feedback from CSLB why it was only 3 years. And so it's a little frustrating that someone can steal that much money in a fraudulent situation, be found guilty, and have a 3-year revocation. So in essence, all they have to do is pay the $20,000 in court fees, and then they can get their license back in 3 years. This should have been a permanent revocation. And I only mention this because, in the hearing itself, we talked about restitution, and we talked about trying to get this referred to in a criminal case, and we had no help from CSLB on this. I want to caution people to understand that CSLB is a very overwhelmed organization, especially with all the disasters. And I don't think they're spending enough time on individual cases to go after. It's only when things hit the media and go really, really wrong that they have to jump in. And I'm not here to pretend to know all the ins and outs of all of the things that CSLB has to patrol. But I will say that the consumer is the number one most important. There is never a situation where the consumer should have a lien put against their property by a subcontractor they did not hire. They hired the contractor. The subcontractor is that person's
You have
problem.
10 seconds.
We should not be in that situation. Anyway, I would love, you have my email. I would love to get help on what I need to do the restitution and get referred to for the district attorney's office. But more importantly, I just want everyone to note, this is a very overwhelmed system.
Thank you very much for your comment. Do we have another one on WebEx?
Yes, we do. Catherine, your line is unmuted.
Hello, can you hear me?
Yes. Okay,
Hi.
yeah, if you could speak closer to the mic.
Sure. Is that better?
Yes, thank you.
Hi there. My name is Catherine Phillips, and my husband's name is Garrett Lamb. We were given this link through Gabriella and Catherine at HPP Cares. We were victims of the multitasker situation going on right now in San Diego and Los Angeles. And I just wanted to kind of point out the obvious, which is obvious, these loans that we've taken out that were signed over immediately to the builders or the companies, and then they collected the money and we never saw them. But the domino effect of that is we bought a house just to build my mother-in-law, who has dementia, a home in our backyard. We moved from LA, moved down here, tore up our whole lives, bought a property big enough for her, and started this process with Multitasker. We took out the loans that they suggested we take, and before they could finish the build, or they never started the build, but before they finished, one of these loans expired, and it was going to have excessive amount of fees on expiration. So we were, suggested by Multitasker to take out a separate loan and pay that loan off. And then, we would take her out of her home that she lives in now, my mother-in-law, and put her in this ADU when it was built. And then we would have rental income from her home. But they never built her ADU. So what we had to do to pay off this loan was refinance the home she was in that she's had for 30 years. Her house payment was $900. And with interest rates today, her house payment is now $3,500. So we've got this elderly woman who's got dementia, whose house payment has tripled, and we have nowhere to put her in order to try to pay the income on this loan we had to pay off before maturity. So I kind of just wanted to point out the domino effect that these construction companies defaulting are having, not just on the outstanding loans, but if you pay off a loan, and where do you get that money from to pay off that loan immediately before this house or ADU is even built? That is causing, I know myself and other people with the Multitasker situation, a lot of other distress and creating a whole nother issue of problems, because now we can't just get the loan company to forgive the loan because we've already paid it off. So how do we go about fixing that issue if we pay off a loan for a property never built?
Thank you for that. Do you have anyone else on WebEx?
Yes, we have Inga Hammond. Your line is unmuted. Inga Hammond, if you could go ahead and unmute your line. Okay, it appears that she dropped off. We have Sydney Brown. Okay, Sydney dropped off too. Amy, oh, there goes Sydney.
I just couldn't find the button. So
Go
I
ahead.
have a little clarifying that I would like to ask about. The ADUs are considered home improvement. Does that apply to a duplex that you already have on a piece of property, and then you put ADUs onto the property? Is that still considered a home improvement? And maybe you can't answer the question right now, but maybe you could send me in the right direction as to how I can find out more about this. Because we're trying to get insurance, and our insurance company is saying that the ADU is separate from the main house, and we're going through a rigmarole trying to have, because they have separate addresses. So, anyway, it may be off topic, but I just wondered.
No, that's great. Do me a favor, put your contact in the chat, and we'll make sure someone gets back to you in writing.
Thank you.
You're welcome. Do you have anyone else in the chat or on WebEx?
Yes, we have Amy Pierce.
Amy, do you have anything on the agenda item?
Yes, sure. Yes, I do. So I have a question I have an issue for consideration. It's recently come to my attention that for all of these individuals that are being victimized by these unlicensed contractors, one of the challenges is that myself and some of my colleagues are finding is that when they go into the court system, that Section 7045 is being used as somewhat of a shield for these unlicensed contractors. And so, I mean, I do think there is a cautionary tale here that even though I think the Contract State Licensing Board is doing the right thing in identifying these unlicensed contractors and citing them, that the cooperation of the district attorney's office and the courts as well is imperative to getting justice for these individuals. And I do think 7045, the way it has been interpreted recently, it is being used to essentially exempt some of these individuals from the licensure requirement under the idea that, these sorts of installations are either not permanent or that this Section 7045 was intended to exempt them from the licensure. So I do think that this is a risk that I don't think was as prominent until more recently, because I do think that courts and sometimes juries are disinclined to punish these unlicensed contractors the way the law is designed by the legislature.
All right, thank you for that. Do we have anyone else on WebEx?
Yes, I have Douglas Washburn. Your line is unmuted.
Hello. My comments are about the general procedure of lien warning with respect to suppliers working on behalf of a general contractor. The customer gets a lien warning if they're doing it the correct way through a certified mail and a receipt requested. That's all well and good. You're at least notified that there exists an obligation to ensure that entity gets paid, but there is no legal requirements on the person issuing the lien warning for reporting outstanding balance levels of the account that gets created on behalf of the general contractor to perform the construction with the consumer. I actually had a conversation with the accounts receivable person. They assured me, oh yeah, the GC that you're working with, you don't have to worry. They always pay their amount on time. But there's an awful lot of hoping, I guess, that the general contractor will let you know and act in a good way with respect to paying their bills. But they're really, the accounts receivable person says, oh no, we can't set up an email notification with account paid or what the current balance is on a periodic basis during the project. So I think there should be, if you are allowed to do a lien warning, you should have a legal requirement to also report account balances so the customer has visibility in what's going on and can take corrective action with the general contractor, such as writing the check to both the GC and supplier. I have no way of knowing, how long I have to continue doing that to ensure they get paid if I don't have the amount information of what the obligation with respect to my project is. Thank you.
Thank you. And if I could just remind everybody on WebEx that we are on agenda item C, comments regarding anchored tiny homes complaints and possible legislative concepts. So we already had the point where we could speak about general comments, but this is specific to the agenda. So do we have anyone else on WebEx?
Yes, we have Vito. We're going to try their line one more time. Go ahead.
Okay, I think I'm unmuted now.
Yes.
All right, so I too, I guess this whole ordeal, just like a lot of the people making the comments today. I was actually an employee slash former subcontractor for Anchor Tiny Homes, and just like a lot of the homeowners, I'm also in the hole a couple $100,000 for unpaid work. And unfortunately, this isn't the first roundabout that I've had with issues similar to this, and hence that why I'm speaking out today in hopes that some change does happen in the requirements of general contractors or prime contractors hiring subcontractors. I believe that one of the changes that needs to happen is in regards to the bond requirements, whether being upping the existing bond requirements that you have in place now, or requiring performance payment bonds in addition to $25,000. Sometimes is just, nowadays it doesn't do anything, especially when we go and file a bond and there are other subcontractors claiming a portion of the bond, and the bond company actually, for subcontractors specifically, lowering our claim amount to about half of what the bond claim is. So in my instance, $12,000 for my $200,000 in unpaid work, in addition to the, a couple other $1 million worth of claims from other subcontractors. The last conversation I had with a bond rep for that, the bond that Anchor had, it was estimated that that each of the claimants were going to receive approximately $43 as a payout. So, it's great that there is a bond requirement, but there has to be something in addition to for these prime contractors getting in contract with multi-million dollars worth of work and hiring subcontractors to do the work. Make it to where it's audited, similar to like general liability. As a contractor, general liability is audited on our end, and we have to provide financial records, tax returns, and such things like that to prove how much our exposure is when it comes to general liability, and then our premiums go up or down based on the amount of exposure. This has to happen similarly to the bond, to where the contractor is actually
Your time is up.
Is based on their exposure.
Yeah, thank you so much for that. I know registrar folks taking notes on that, and we will look into that. Thank you. Anyone else on WebEx?
We have Katie Lucas. Go ahead.
Okay, thank you. One note that I wanted to add in, about complaints to the CSLB on behalf of Anchor Tiny Homes was previously you could not find a complaint about Anchor Tiny Homes on the CSLB. And a big part of that was they were paying their customers off, whether it was trips to Disneyland or paying them in a lump sum. They offered me $19,000 to remove my complaint from the CSLB and from the bond company. And my problem with that is when you file a complaint with the CSLB, part of the process is for us to negotiate some term of agreement. Well, part of that term of agreement could be them giving you money and then you removing your complaint from the CSLB. My problem with that is that removing your complaint from the CSLB, it takes away so much from consumers because that company was still a problem. And even though they were paying individuals and writing them off, they were still getting new customers and creating the same problem. Had there been some type of a liability where those complaints are left on there, or at least saying there was a complaint about this company, but it was taken care of, some form of evidence that there was a complaint on them, I think we would not be in the situation we are in today because many people would see that and not hire that company. And that's all I have to say on that.
Thank you for that. Do we have anyone else on WebEx?
We do not have any more public comments on WebEx.
Okay, thank you very much. And I'd like to go back to the audience if anyone does want to speak.
Thank you very much. I feel very vocal today. I don't think we've had an opportunity to thank CSLB for the work that you've done. The Scan by Anchor Tiny Homes group was created on July 19th, and we are here today. I have worked in state government for almost 20 years for a large agency, and spent a little bit of time in fraud detection and fraud prevention. Spent a little bit of time developing applications for fraud referral, and I know it's very important for our constituents to be able to get that information across when there's a lot of bureaucratic tape. And so I believe you guys have taken an extreme look at this. I know that you've pulled resources out and to come back to investigations, and I just want to say thank you for that. I also want to say that as you were speaking about administrative protection and what the board can do, there are a couple things I think that are important. The first is there's a lot of people experiencing bottlenecks right now in permit processing. There's a lot of, even though that is in the jurisdictions of the counties and the cities, there's a third-party company called Permit Flow, which is a coordinator, which is a third-party company that was hired by Anchor Tiny Homes, unbeknownst to the folks here, that was handling the permit process for their ADU. The consumer had paid, and the contractor did not pay them, and now they're holding their permits hostage, essentially, in some counties and cities. And so in addition to the financial burden, they're also not able to move forward. And so some type of memorandum that would kind of help to say, can we take those permits and put them back in the homeowners' names, and so they can find a general contractor who is worthy of that project to move forward, would be very helpful. Another thing I think that would be helpful is CSLB's website showed a maximum of 10 complaints that were being filed. When we talked to an investigator, someone had said there were over 200 complaints that they had received, and they are frantically working these cases as fast as they can. I don't think it would make sense to post all 200 of those complaints online, but it would be helpful for our ADAs and our Office of Attorney General who's listening in to know that there's been that many complaints that are coming forward. And this is on behalf of 450 plus customers, 57 employees, dozens of contractors, and over 100 franchise owners that span 26 states. We're talking 30 million and growing. This is a Ponzi scheme. This is not contractor fraud. There's so much more involved here. If we can show those complaints online to at least say, we have 249 complaints that we're currently working through, I think that says a lot to our local DA's offices. And lastly, I think that we can do a lot more to hold hands with other state agencies, including the Secretary of State and the Franchise Tax Board. If we have a means to file fraud, can we hold hands with those other agencies and not only look at redacting or revoking their contractor's license, but also how that should impede their business license moving forward? That's all I have for today. Thank you.
Thank you so much.
I've spoken to a lot of you already. My name is Jan Kaufman. I just wanted to say thank you again to all of you for putting this meeting together for all of us. And I especially want to thank Andrea, there you are, and Katie, who put together the Scam by Anchor Tiny Homes. They have all kinds of how-tos, how to work with the DA, how to, reaching out to an attorney, how to work with the licensing bureau. And they have been such a wealth of information that has helped all of us. We all came in this blind, and now our 2020 vision is starting to come back. We're starting to learn what to do. So I just wanted to say thank you on behalf of me and everybody else too.
Thank you so much.
Good day. My name is Catherine Peoples. I'm the Executive Director of HPP Cares. We are a 501c3 nonprofit down in Southern California that has and is administrating many of the CalHAFA ADU grant funds for the state. We were the organization that went viral. With that said, we are HUD approved, and we are managing quite a few projects, anywhere from 2,500 to almost 2,800 projects throughout the state of California. We've done the work of outreach, underwriting, and we offer a managed escrow. Some of the victims that are in this room, as well as other organizations that were mentioned during the call today, Multitasker included, as well as ADU Works, which those are going to be coming down the pike as well. Our organization has and been made aware of. We've thus put in the complaints. We've been supporting the families in various aspects. I'm here today to tell you that we caught and knew about Anchor Tiny Homes, and we're trying to put the lights out with all of our clients, letting them know, hey, don't make payments to these companies. We didn't lose grant funds, but only for 3 of the families, and it's because of our team at HPP Cares, our fund control, and our management of our program. We are doing an amazing job. So if you are looking for a solution for managed escrow, we are the organization to do it. We've been through it. We've seen the loopholes. We've figured out how to monitor and manage construction companies and mom and pop organizations that are doing this and victimizing families. So we are the solution. HPP Cares is here on the scene to provide the education, to provide the verification of licensing, and to do the management of funds. Someone mentioned earlier that it's 8% or it's thousands of dollars to do that. Our organization takes on a nominal charge, very small, and we do the work of managing, releasing the funds expeditiously, as long as everything checks out, as well as we do the necessary inspections. So you basically have the solution here in Southern California to do what needs to be done to protect all the families that are here. Unfortunately, we just weren't taking care of their projects because they weren't participants in the California ADU grant program. That's my comments.
Thank you very much.
Hello, I'm Gabriella with HPP Cares. As a HUD housing counselor at HPP Cares, we always focus on educating homeowners on buying and retaining their homes. We've seen incredible success in programs like the CalHAFA ADU grant, helping people access those vital funds. But what we're not seeing enough of is education for homeowners on the actual construction process itself. There's a gap in the system. Homeowners may know how to access grants and loans, but they don't know how to manage the complexities of construction. They need to understand key information like average construction costs, realistic project timelines, payment phases, bonds, managed escrow, and the roles of subcontractors. Basic knowledge of these topics can help the homeowners make informed decisions and avoid the common mistakes during the projects, both in ADU construction and in home improvements. We believe in expanding the education efforts to include more support for these homeowners who are navigating construction. We believe that a well-informed homeowner won't just be better prepared financially for these projects, but they'll also be able to complete these projects with less stress. That's my comment. Thank you.
Thank you. Do we have anyone else in the audience? All right, with that, I would like to thank the committee members and public for sharing their thoughtful feedback today. Committee members and CSLB staff will further research and vet ideas and submit feasible concepts to the full board for consideration at a future meeting. The board will then determine which ideas might be crafted into legislative proposals. On behalf of CSLB, we appreciate the public's input today and will continue to ensure future opportunities for the public to participate in this process. John, would you like to make a statement?
Sure. I just wanted to emphasize before the meeting ends that public education is why we're here today. Public protection is what CSLB does, and we can't do it without the public. So I think it's been emphasized before, but it can't be overemphasized that CSLB can't act without honest, hardworking homeowners and other complainants coming to CSLB and bringing these things to the attention of CSLB. So now we can get ideas to further educate the public so we can weed out some of the bad actors. And I just wanted to clarify for, I think it was Amy and Douglas and some others who were talking about financial injury. CSLB is a statutory creature that is providing, to the best of its ability, construction workers with to minimum standards, and we rely on the public to make sure and administratively discipline them if they're bad actors. The idea of, we've heard a lot about financial harm, and I know there's people that said it's tough to find lawyers to help them with that, but it has to be somewhere other than CSLB because we are not tasked and don't have the ability to collect for folks that are harmed like you. So I just want to let you know that we're here as a sounding board, as a committee, and we are taking everything to heart that's been provided to us, and it will get to the board's attention. Thank you, Chair.
Thank you for that. Do I have a motion to adjourn?
So moved.
Motion by Cobos. Do I have a second? Second. Second. Any opposed to the motion to adjourn? All right, we stand adjourned. Thank you again for attending.